Hello and welcome to this week's edition of Wednesday Wisdom. This is our weekly video snippet edition of our sidebar, which is our monthly newsletter. So these are mini sidebars just designed to give you some really quick tips and bits of information on a weekly basis. So this week, before I get started, let me start my timer because these are designed to be less than 5 minutes altogether. But this week I want to talk to you about blended families. Those of you out there in those blended families, let's say you have some stepchildren, you've remarried and acquired some additional kids in the house, which is always awesome. Hopefully for you it is, but let's say you do want to provide something for those stepchildren because you consider them yours now, and they are yours now. If you don't provide for that in your will or trust or some other mechanism, you're going to let the state decide for you. And if the state decides, guess what? They don't get anything that you are intending for them to get. The rules of intestacy here in Georgia, the heirs kind of fall down after your spouse. If you don't have a spouse, it goes to your children, and those are children who are born or adopted. Unfortunately, stepchildren don't count in that determination according to the eyes of the state. So, and I'm talking about Georgia here. So just be aware of that. Again, it's something that you don't automatically think about, but you really need to think about that and all the many things that you have to consider. That is one of the big ones there. So as always, I'm just here to help and kind of put that nugget in your ear, and hopefully you can plan accordingly. So as always, thanks for watching, and we'll see you next time.